What every Social Security disability applicant who has colorectal cancer needs to know about steps 4 and 5 of the 5-step sequential evaluation. If you don't meet a listing at step 3, your benefit determination will be based on the medical and vocational criteria of steps 4 and steps 5. At step 4, you have to show that you can't go back to the lightest physically demanding job you held in the 15 years before you became disabled because of your residual functional capacity. And at step 5, there isn't any other work that you could do in the mythical national economy based on your age, education, skills, and that residual functional capability. Now, many times when people apply for Social Security disability benefits, their records are silent about what it is they can do despite their colon cancer. That's residual functional capacity. If the Social Security Administration can't figure it out, they're going to send your medical records out to a medical consultant. And you can be assured that that consultant will opine that your physical and cognitive capabilities are such that you could go back to the lightest job you held in the 15 years before you became disabled and could do other work. That's why it is crucial that you have a residual functional capacity form completed by your doctor. The lower your residual functional capacity, the more likely it is you'll get your Social Security disability benefits. The Social Security Administration isn't going to tell you about the existence and importance of a residual functional capacity form. And it can make or break your Social Security disability claim. The cancer forms will normally ask questions like how far you can walk, how long you can sit and stand at one time and for an 8-hour day, how much and how often you have to lift, stoop, squat, and bend during an 8-hour day, whether you have problems with fatigue, whether you have problems with the side effects of treatment, such as chemo fog or tingling and numbness in your hands or feet. That's crucial because if you have problems with your hands bilaterally, you would be unable to engage in most occupations. Whether you have to take unscheduled restroom breaks, how often you have to take those breaks, how long would you be in the restroom? Now I know that's difficult to talk about, but if you can't maintain the pace required of the job, you'll get your benefits. So don't be shy about telling your doctor about those symptoms. Whether you have good days and bad days, how many days per month you'd miss from work, whether you have problems with depression and anxiety that would interfere with your ability to work. This isn't an exhaustive list of all the questions that you'll find on a residual functional capacity form, but you can see that having an explanation of what you can do physically, cognitively, and emotionally is the key to winning your case. Now, the other key to your case is the vocational aspects of your case. As I said, if the Social Security Administration can't figure out what your residual functional capacity is, more likely than not, you're going to be denied initial application stage and the request for reconsideration stage. So that means you're going to end up in front of a judge in a trial. What's going to happen at that trial will make or break your claim for benefits, because the judge will first determine what your residual functional capacity is. And if the judge can't figure it out, more likely than not, they're going to provide a hypothetical to the vocational evaluator that will lead that evaluator to say that you can go back to the lightest job you held in the 15 years before you became disabled, and there's other work in the national economy. But even with a residual functional capacity form, the judge can still formulate the wrong hypothetical. So let me give you an example. Let's say that the judge turns to the vocational evaluator and says, I want you to assume that a mythical hypothetical person, just like the person sitting here, can sit for 6 hours, stand for 6 hours, lift 10 pounds. And that's all they ask. The vocational evaluator will probably say you can go back to the lightest job you held in the 15 years before you became disabled, and there's other work you could do. If there aren't any more questions asked of the vocational evaluator, you're going to lose. Now, that can get worse, because if the judge asks the next question, is there other work in the national economy this person can do and move their age, education, and skills? And that vocational evaluator rattles off 3 dumb jobs like addressing envelopes, rolling up silverware in a napkin, or folding laundry in a laundromat. You're going to lose. It would be helpful if the judge added to that hypothetical the real problems that you have because of the side effects of your treatment, or the problems you have with fatigue, or the problems you have staying on task, because those are the real meaty questions that should result in the evaluator saying that you can't go back to the lightest job you held in 15 years before you became disabled, or the simplest one, and there isn't any other work that you can do. Hopefully you now understand why I think that it's crucial that you have an attorney represent you at the initial application stage, where people make mistakes with their work history and don't get a residual functional capacity form, at the request reconsideration stage, where they make the whole set of mistakes all over again. Do you know that over 2/3 of Social Security disability applicants are denied at the first two stages? And of course, you don't want to go into the lion's den of a hearing without having an attorney. You don't know anything about the 5-step sequential evaluation, how to get a residual functional capacity form, how to present your case to the judge, how to testify effectively, and how to cross-examine that vocational evaluator. Odds are in your favor if you are represented by an experienced Social Security disability attorney. So call me today, 727-894-3188. Make the call, Cavey Law.